All right, good afternoon. We're going to go ahead and get started. This is Judiciary Non-Civil Hong Subcommittee. And before we start, I want to point out a few judges that are here today. Chief Judge Cynthia Adams from Douglas. Thank you. And Judge Trey Taylor from Dublin. Thank you. Okay, let's move forward. We are going to hear from Representative Brad Thomas, House Bill 171. Chairman Thomas, when you're ready.
Am I on here?
Yeah, got mic.
Thank you, Chair Lady. So I'm here to present House Bill 171. Make sure everyone has the right LC number 492253S. As most of you know, we had a significant amount of debate or a conversation about this bill. I guess it was last week. Feels like it's been a month ago. And there was several comments and questions and fixes that needed to be looked at, specifically with regards to 161280. There was some issues with that constitutionality of that particular provision. We actually made this a new section now instead of repealing and replacing the old one, and we did that by adding .1 after the 80. So that took care of one of the major problems. One of the other issues, and I'll let Pac, if you don't mind, let you come up and talk just really quick about a small fix that Pac has requested as well, which I think was a great pickup. So.
Okay.
All right. Which one are we talking about?
We're talking about 171. That was the language where the fence.
Oh, about what we picked up is.
Can you just say your name?
Robert Smith of the PAC. One of the things is that this is a sentence enhancement for if it's proven that AI was used. And one of the things that it calls for in this is that the judge should impose a sentence of at least 2 years. The problem is that some of the other crimes that are covered by this already have mandatory minimums of longer than 2 years. So there could be a confusion or an argument made that basically, like for a crime that has a mandatory minimum of 10 years, if we proved that AI was involved, it actually would reduce the mandatory minimum to 2 years. So some language has been added to make sure that the sentencing judge understands the difference and knows to default to the original mandatory minimum rather than the lower one.
And that's line 104 through 106. Is that what you're talking about?
Here, I got you right here.
Yes, thank you. Yes, ma'am.
And you're essentially talking about all the designated offenses starting from line 67, and you're stating that some of those offenses have minimums that are more than what we're designating in line 94, correct?
Yes, ma'am.
Okay. And so therefore we have that line 104 through 106 stating that if it is, then we go with the enhanced sentence. Am I understanding that correct?
Actually, it's in, I think it's 95 through 97 that talks about what to do. That if such designated offense is subject to a minimum sentence of imprisonment for 2 years or more, the judge shall impose a sentence of imprisonment for not less than the minimum plus 1 year.
And then the judge has to state it in 104. Okay.
Yes, ma'am.
Okay. Anything else?
No, this was just we've already. Oh, sorry. Again, this was to follow up on the debate, the conversation that we had in the committee last week, and this was to incorporate the comments, and I believe that we've picked them all up. So.
And I'll open up to questions for now. Any questions from members of the committee? Representative Byrd?
Yes, thank you. Listen, sometimes I get very confused in this committee, but is this adding another hate crime? Is this going to be used as a hate crime if anyone depicts a child for AI?
I don't think depicting children is an artificial intelligence making explicit videos of them has anything to do with a hate crime. I think that there's probably some underlying foundation out of the hate crime statutes, but it's not it doesn't make a hate crime. So,
Thank you.
Any other questions? All right. I may have a suggestion on a section, but let's just hear from some of the witnesses first. You need to go.
No, you're okay. If we
Is that
got
okay?
people that are want to speak, absolutely.
We have
I'd be
2
happy.
people signed up. And Chairman, if you need to go, we can hold and then maybe come back if you want to. Okay. All right, thank you. DA Herb Cranford.
Madam Chairwoman, I've read this, and the issue that was brought up last time is addressed by the change. So if y'all would like to ask me questions, I'm happy to sit down, but I don't have anything else to
Okay,
to add.
thank you. Maisie Lynn.
Unlike DA Cranford, the issues that we raised have not been addressed, but I don't have any new comment. I just would still encourage you to protect teenage children with a carve-out like you have in the other code sections.
Okay. All right. Anyone else? I only see those 2 people signed up for this one. All right. Chairman Thomas, if I can suggest, I think just in that section before, there were some concerns as far as possibly social media companies and how they handle essentially processing or distributing such, and whether or not they're going to be liable. And so there was previous, I'm going to go ahead and hand out this language, but essentially it's the same language that we had in the previous code section, section OCGA 1612-100, where we'd made sure that essentially those companies, if they see such material, that they have to make such reports and immediately, and any type of transmission to law enforcement of such material would not be considered distribution. So kind of protecting and making sure that anybody that's reporting it isn't considered as distribution. So wanted to see if you would be open to adding that language again, which is the same exact language that we had vetted before when we were doing this obscene statute, and putting it into this code section.
I absolutely would be open to that, and anything we can do to help make sure that this is prosecuted properly. I would be supportive of any of that language. So.
Okay. Thank you. And so, and everybody has that language on your desk. Any questions from members on that? Okay, so then I'm going to go ahead and do it as a amendment to this HB 171. On it? No. Okay. Okay. So I don't see any questions. Do we have, I'd be open to any motions at this time. Are we move in a second? Do we have any discussion? I don't see any. And I'm going to go ahead and offer, again, that amendment. I'll just call it Hong Amendment to HB 171. Do we have a second?
Second.
Do we have I was asking you to second. I was saying I'm going to move to pass Hong Amendment, and we have a second. Any discussion on the Hong Amendment? Those in favor of the Hong Amendment, say aye. Those opposed, same sign. All right. And we do have a move and a second on the HB 171 with the Hong Amendment. Those in favor of passing that, say aye. Those against, same sign. All right, it passes. Thank you. Thank you, Chairman, for sticking around.
What's the full committee? When? It's on Saturday? Sunday brunch? Okay. Thank you. I appreciate y'all.
Thank you. I want to go out of order here real quick, and I understand we're going to go ahead and Representative Penich, we're going to take off HB 354. So we're going to take off HB 354, and we're going to hear from you on HB 460. Or you can sit there, whichever. I feel more official. Hello. So I brought this bill because it was something that for a long time I thought was already happening, that lawyers were not being recorded in the jail talking to their, or shouldn't be recorded talking to their clients who are in jail. Because without a warrant, lawyers who are talking to their private clients can't be recorded either. So I read the case Burns, and I practiced in criminal defense. I frequently see clients at the jail, and sometimes I have to talk to them on the phone because it's impossible for me to get to the jail in a timely manner if they have something that we need to discuss. They usually have to call out, and there's always a recording that says your call is being recorded. At that point, normally, I say my name, my bar number, please stop recording, and then lo and behold, they don't stop recording, and prosecutors can listen to the conversation. They just can't use it in court because of the privilege rules. But that doesn't mean they can't listen and learn things in the interim. So this bill is to solve that problem. And there was a case, a Supreme Court case, Georgia Supreme Court case, Burns, which I left at my seat, which essentially says that you can't use lawyer-client communications as evidence, but then they did in this case. And so I want to make sure that there's no ability to record a lawyer talking to their client without a warrant by a judge because they have suspicions that the lawyer is communicating for purposes of fraud or something that is definitely not covered in the privilege. So that's what this bill is. It instructs each penal institution, whether that's a jail or prison, shall provide access to a non-recording telephonic or electronic device for a client held in custody to communicate. And then there are remedies in the event that the conversation was recorded without a warrant. Anything else?
Nope, I can answer any questions.
All right. Any questions from members? All right. Representative Sullivan. Is that me? Yeah, I think that mic's not good. Let's try 17. Nope, that's not working either. Oop, we're not doing 16. Let's do 15. Oh, my goodness.
Sounds like a rap video for sure going on in here.
How about if I speak loudly?
Can you try 17 again?
Okay, sorry. 17. Is that better? Hello? Hello?
It's not working.
16? Hello? Hello? Hello?
Push 18.
Hello? 18.
Heck yeah. Go ahead. Can you hear me now? Testing, testing.
No.
Sits.
Is that one working?
Is that one working?
I don't know.
Working out. We got one. We got a heartbeat.
All right. All right. And now it's really high. Okay.
There we go. Now it's
Sorry about that. Okay.
All right.
We'll need to report all those mics. Okay.
I do not practice criminal defense law, but I was just curious because I know there's been a lot of controversy about prisoners having cell phones. And so my question is, do they have cell phones? And are these cell phones intercepted? Are they allowed to have cell phones? What's the deal on the cell phones?
Cell phones are contraband in the jail. So
That's what I thought.
I don't know a jail or prison that allows an inmate to have a cell phone.
But somehow they get them.
That is beyond the control of this bill.
Yeah.
That is
And
has-
or a subject of this bill.
right or a subject of this
Yeah.
bill.
I'm just curious about just the cell phones. Yeah, it's a real problem.
It's a problem.
And so I guess if someone has an illegal cell phone
If-
and they talk to you in the jail, what happens then?
So I actually got a call once from a client, and it didn't say I'm calling from a facility because that's
Right.
usually what the recording says before the person gets on.
Right?
I said, "How did you get through to me?" And then I hung up the phone because I know it's a contraband and I can't aid in my client committing a crime.
So there's a
So-
protocol where they are on a line that is controlled by the jail, typically.
Yes.
Okay.
Yes.
Okay.
And that's what we're asking for, there to be a separate line or a line once a lawyer puts in a code that's given once they enter an appearance into the
Okay.
case that says, that is not recorded. Now, of course, if there is some suspicion,
Right.
then the law enforcement can go and get a warrant to record the conversation if they meet that threshold.
But if
short
they
of
were on
that-
an illegal cell phone, could that cell phone be subpoenaed and the conversation not be under privilege?
This is beyond what the jail is doing, so the jail wouldn't know about the cell phone. That's
Right.
itself
I'm
a
just
crime.
saying that's a
So-
crime to me. Yeah.
Right, but that's not,
Okay.
this bill doesn't affect that at all.
Okay,
It's
great.
still a crime, yes.
Yeah. Thank you.
Thank you. Chairman Smith?
Thank you, Madam Chair. Representative, I really appreciate you bringing this. There was a situation of where a lawyer may pass away and have a client in jail or in a prison system here, or a penal institution, I think is how you've written this out. And if they're no fault of the client, let's say they're picked up on a bench warrant and they're in the local jail for whatever reason, and they need to get in contact with their counsel. Counsel has no clue that their client is currently in custody unless we have either ourselves or those that help keep our firms running every day, especially while most of us are here. We wouldn't know that they're in custody. And that's really part of this aim too, this legislation, if I'm correct.
Yes.
Okay, thank you. And is it also true that, notwithstanding all of us not minding to make that trip to whatever jail our client may be in custody at, that in this 21st century, I think, we're 25 years in now, and the fact that this is the issue is just mind-blowing, despite what certain folks that have a say-so on a certain other side of the street, that this basically protects the attorney-client privilege that has been sacrosanct for centuries.
Yes, Mr.
Thank you.
Chairman. I would also add, this may take some of the burden off the sheriffs who have to arrange, if a lawyer says I'm coming to visit a client, or they just show up because they can, sheriffs have to take corrections officers from what they're otherwise doing and then set up an interview room for the lawyer and the client, which isn't recorded, but if a lawyer can call in to the jail on an unrecorded line, then it may not necessitate an actual visit, which would take up resources from the sheriff, which their resources are already low.
And Representative, just one more follow-up since you brought it up. Is it true that although since COVID things have gotten better, there are still some very restrictive requirements put on attorneys? I know in a certain county just west of here, if I don't make it by 4 o'clock, I have to wait until 7 o'clock to go and see my client, which that's great. Don't mind doing it. I've been at the jail at 10 o'clock at night before and past talking to a client, but really it's hat in hand for a lot of defense lawyers going to see their client, trying to make sure that we get in to communicate, whether it's for preliminary matters, pretrial matters, or whether it's in preparation for trial. There are a lot of hurdles that are in place, and our clients having the presumption of innocence to really make that effectual, being able to communicate with their attorney is paramount.
Yes, and every penal institution I've ever been to, and I've been to many, have different rules. So the rules aren't uniform either.
All right, Chairman Crow?
Thank you. I just want to make sure we are doing 354 and not doing 460. We're doing 460,
Yes.
not doing 354. See, that's why I asked the question.
That's correct.
Because I was on the wrong one.
Okay.
Okay. That's what I needed. Thank you.
All right, thank you. Chairman Gunner?
Hello.
Hello.
All right, so this bill doesn't undo the Burns case. Is that correct?
This would stop the recording. In Burns, there was already recording, and it was listened to.
With a warning that the call was being recorded.
Correct.
And the courts upheld that under Burns.
Correct. Can you pass me Burns? There was a whole case. Thank you.
So I guess my question is this going to change the law so that even if the attorney's warned by the recording that it's being recorded and still goes forward with conversations with his client, this is going to change that, and that won't be allowed in even if he heard the warning. Is that correct?
There wouldn't be a recording on a call. We wouldn't get to Burns because there wouldn't be a recording. There wouldn't be a recording. Burns there was a recording, and that's how the lawyer knew to say, "I'm a lawyer, please stop," and it wasn't. This bill would provide a non-recorded line, unless there's a warrant.
But if they call in on the line that is the recorded line, because they do that.
If a client called me from the jail and it said it's a recorded line, I would say, I'll call you right back on the non-recorded line and have a real conversation.
Yeah. Well, what's going through my head is they have a line that anybody can call in, parents or relatives or whatever, talking to the inmate in there. They have that, and they have the warning on it that anything you say can be recorded.
Correct.
Okay. But if a lawyer chooses to call in on that line.
No, so Judge, the calls that clients have to call out generally. And that is a recorded line, and it says this is a recorded line. People can't generally call into the jail and speak to an inmate.
Okay.
So that line
So
states,
if he chooses to call his attorney on that line.
right,
You're saying that that's not going to be admissible in court.
well, it shouldn't be admissible in court anyway because it's privileged. But the issue will really be kind of sidestepped because the lawyer will say, I'll call you back on the non-recorded line and have a real conversation. People who are not lawyers will not have access to that.
I agree that's what people should do.
Well, that's what this bill says.
Okay, thank you.
So this is how I understand it. Line 1314 is essentially the jails have to provide access to non-recording line, etc. But starting 15 is if there is communication that is intercepted, then it shall not be received in evidence unless there's a court order, application, approval. Is that correct?
Yes.
Okay. So what Judge Gunner is saying is if some first year lawyer has no clue and is recording all the things, and it happens to be there, and then it's still not admissible unless there's certain other things that, unless there's a court order, there's application. Is that correct?
Yes.
That's how I'm reading it.
Yes.
All right, Chairman Crow.
Okay, now that I'm looking at the right bill, I know what I'm talking about. So on line 13, it says each penal institution shall provide access to a non-recording telephonic or electronic device. How is that, functionally, how is that going to happen? So is every jail and every prison and every cell block or everywhere they have telephones going to have to go back in and install new phones that are not recorded? Because those are recorded. They usually have companies that provide those phone systems, and if they do, or if they have separate access to it, how often are they going to be required to get access to that? Does that make sense? I'm trying to think functionally, like if they want to call their lawyer, do they have to be able to let go to a special area to use a phone that's not recorded? Just trying to think practically what kind of burden this is going to put. And the only reason I ask is we're already fixing to spend a bunch of money on Department of Corrections to fix things that are already need fixing. I'm just trying to figure out practically how this is going to work. You certainly can't put an unrecorded phone in the cell block with them because they will call everybody but you.
Correct. Correct.
And so I'm just trying to figure out practically how you would see this working, or what the intention is for you, and how this is going to be set out for them to comply with this.
The way I see it, so companies like Securus, who work with the jails, usually you have to put in some type of code. The client has to put in their own code. The lawyers should get a code that we can put in that would stop the recording.
That's possible.
That's how I see it happening.
Is that possible?
Chairman Smith, I think you may have an insight on that.
So within the last probably decade or so, what you've seen, a lot of jails are installing kiosks for clients to use. That includes everything from, they can send text messages and or emails now. And so building this out in that kiosk setting will not be that difficult. Different software or different vendors that the sheriffs and police departments use, this would be something that they could build out through that server that they're using to facilitate the phone system in the penal institutions. It sounds like it'd be a complicated issue at first. I mean, I'm sure there's certain, and I have been in counties still to this day that have an old school system, but most of them are going over to these kiosk type deals. And I think that usually, instead of being in the whole cell block, I mean, there's a few that would have one, but there's a section for obviously only the client can come into the designated place to make a phone call. There's a door they can shut. I think this would be a suggestion for those implementing it. It may be best to put this in the attorney booth. There's a separate attorney booth in most jails for attorney visits. I think that would facilitate this the best, but I'm not in IT, but seems like if they can put these kiosks in for email and everything else, they would be able to accomplish this. That's my understanding.
That's my understanding too. And I know DeKalb Public Defender has a separate line that they can talk, an unrecorded line that they can talk to their clients through.
Chairman Crow.
Okay. Yeah, and I don't doubt that the technology exists. I'm sure there's a way to figure it out. I'm just a little concerned about the cost, especially for some smaller jails and departments. And I don't see a time frame for them to get this established. How long they're going to have to come into compliance with something like this, or because there may be some places it's going to be real difficult for them to, some of your smaller jails and some of our smaller counties may have a hard time. It may take a little while to get the funds to do something like this. I agree with you. I think most of them, not all, I've been in some jails, when I worked in many years ago, we did have separate attorney-client booths, but a lot of them, some of your smaller ones don't. They just have regular visitation, and they don't have the separated rooms. And so I'm a little concerned about how long jails and penal institutions are going to have to comply with this to get this done.
I certainly wouldn't object to putting it further out than a July. Let's say if the law is supposed to take place in July, if the governor signs it and it goes into effect, then that would normally be the time of compliance. I don't have an objection putting it a little further out if we can, to effectuate compliance with it. And I think that might be a question if somebody's here from the sheriffs. I don't know if they're here or not.
Chairman Leverett?
No.
Thank you, Madam Chairman. Is this working?
No.
Oh, sorry.
So it needs to be over here?
No, we all of those are out.
Loud?
You come sit right here.
Right there. Sorry.
This one doesn't work either.
Musical chairs.
Oh, yes, it does.
Okay.
It's the hot seat.
Broke all the mics near me, Rob.
All right, is that better now?
Yes.
All right, thank you. All right, and there's nothing like walking in late to a meeting and then asking much questions that have probably already been answered, so I apologize if I'm about to do that. But just two initial questions. There are some references to federal court and authority of the United States. Can we prescribe by statute for what happens in federal court or in a federal facility?
Or authority of the United States.
17 and 22, line 17, I'm sorry. Other proceeding in federal or state court.
I'm happy to take out federal. It really should be state. I'm not aware of any that this could impact a federal proceeding.
Right, I just didn't think we could prescribe. I don't think we have jurisdiction
I don't think we do either.
to do that. So that was one little technical question. But I don't know that much about prisons. Would just like to say publicly, I haven't had a lot of experience inside them.
As long as you can walk out the way you walk in.
That's right. And so Chair Lady Hong summarized the bill a minute ago, and I'm sorry I did not attend to her statement as well as I should have. As I'm reading this, it would make any recording of a phone conversation between an inmate and counsel inadmissible unless it was done pursuant to an order. Is that correct? Okay. So you would basically prohibit what seems to be the common practice now of just recording everything with a disclaimer.
Correct.
Okay. I'm just curious, have you had any dialogue with the Sheriff's Association or with DAs about their position on the impact of such a rule?
I spoke to the sheriff this morning, and they were neutral. And I know PAC is here.
Okay, I imagine we'll hear from them. I just was curious if you knew. All right. And those are my questions. Thank you.
Thank you. Any other questions from members? All right, we have a few people signed up, so I'm going to start calling, starting with Maisie Lynn. And Bert Cohen.
Yes. I am joined by one of our lawyers of the week. This is Bert Cohen.
Good afternoon.
Bert practices mainly in Cobb County, has some experience both at the beginning of his career as an assistant district attorney and actually recently also a couple of years in that space, but majority of his career has been in defense. And he has some current firsthand experience with these kind of communications in Cobb and can tell you a little bit about how it works there. I realize there's been conversation about codes. When I've talked with sheriffs and other people who also are familiar with the communication systems, and I know that in our cases, when there is a target conversation that's sought, what happens is, in those situations, the subpoena that issues is for a particular phone number with whom the person inside the correctional facility spoke. So, for instance, I happen to have a friend as a defense lawyer who the state wanted to hear her phone calls. And so they issued a subpoena for her cell phone number and said to Securus, give us all of the calls that have involved this cell phone number in this county jail. And that's how they got them. So my understanding from at least that one platform would be that, I mean, the devil's in the details, right? But that defense lawyers would have to opt in, providing our number, so that there isn't a way to game the system. Like, you would know that it was the lawyer's phone number that was the party to the call. You know, I realize, as you were saying, Chairman Crow, that there are a lot of differences between our facilities throughout the state. But those facilities that are handling large volumes of people that are in and out of them, most of them do have some kind of this electronic communication functionality. And so, you know, to Chairman Smith's point, it ought to be easily effectuated. And those are the places where today the defense bar, because of the Burns case, feels like we do need to have in-person visits with our clients in order to protect our conversations. And what's critical about Representative Panich's bill, to us particularly, is the privilege that it confirms in lines 10 through 12, that it indeed is privileged communication. And this does not only apply to the criminal defense bar. This will apply to civil lawyers as well who happen to have clients who find themselves in a penal institution in our state. I mean, so it's not limited in that way, and would afford all of those lawyers the opportunity to have conversations more efficiently and without taking, as Representative Panich mentioned, time away from the correctional officers that are in these facilities that doing their typical jobs there. Did you want to speak to some of the particulars that you've got?
There's basically two companies, maybe more. As far as I can tell, there's Global Tellink and there's Secure US. Those are the two contractors that handle the phone calls, and they're all recorded on a hard drive. And I saw Secure US states that they save the information indefinitely. They have the ability, if the jail wants to pay for it. I know Global Tellink, which serves Cobb County, you can just list your number with the sheriff, and the sheriff will instruct the software not to record the lawyer's call at all. But that's for us. I'm in Cobb County lawyer. I know that's done. Outside Cobb County lawyers, as in the Burton case, they say, I'm a lawyer, this is my bar number, and you shouldn't record this call. Frankly, I wouldn't do it that way because it says over and over again, the call's being recorded. So this protects a lawyer who doesn't know the ins and outs of the systems like a local lawyer would. You ever hear the term home cooked? It's I guess it's the way you get home cooked. Also, to have this in place, you're protecting against ineffective assistance of counsel claims, because a lawyer, and it's happened to me, I've been a lawyer a long time, you start talking to a client on a call, and I don't take these calls anymore because of that recording. Even though I'm listed, I'm afraid to take these calls because I'm not sure I trust those collect calls. I'd rather do it on video or go to the kiosk at the jail and talk to them directly. But it would be ineffective assistance of counsel for a lawyer to talk about the case on a recorded call that may be recorded. So that's ineffective, and that could be grounds for reversal. Or a lawyer will avoid talking to his client who is in custody because of that. There's fewer contacts because of it, because the lawyer thinks, I believe my call's being recorded, so it's a lot harder to prepare for a case. And who's in custody more often than not is somebody who's indigent, who can't afford to pay bond, can't get a bail. So that person's being treated a little unfairly compared to somebody who can pay for a bail. So the legislation's important. Also, the logistics. One other way, I know I dealt with a prison once, and I'm sure the small county jails have something similar. If I want to talk to my client, they let me talk on the jail counsel's line, and they assure me, and I trusted them in the past. This is the Masters in Social Work or the psychologist's phone, and the client would actually go into the counselor's office and talk privately with me. So that's worked in the past with some South Georgia, at least one South Georgia jail that I dealt with. So even if it's a small jail, they can say, okay, we'll lead you to an administrator's office and we'll shut the door, maybe watch you through the window, but we'll shut the door, you can talk. So even if you're not using GTL or Secure US, a small jail can accommodate a lawyer and a client in a confidential call. Also, you save on the logistics. A lot of the prisons are pretty far, like for those in the metro area, you have to go down to Jackson and down to I-20 and several hours drive to talk to your client, and that's not a good use of time. And I'm sure the jail doesn't appreciate, the prisons don't appreciate us having to go there. So I think they would want us to do something electronic also. So I think the accommodations could be made for a lawyer and making a call. Oh, and one other thing. In the Burns case, the Supreme Court said, well, the conversation was irrelevant. It was about the lawyer's summer home or something, or his dog, really irrelevant. But what's irrelevant in that case, what may look like irrelevant, it could be the fruit of the poisonous tree. It could be used by law enforcement to get relevant incriminatory evidence. And I think that's unfair playing field, I think. It could lead to other things when you start talking about chit-chat. Can lead to something that's pretty relevant and inculpatory. So I think for those reasons, I think this could be done.
Thank you. You have several questions, actually, Chairman Smith.
Thank you for being with us. I'm sure, and I wanted to just point this out, we meet several times in a 3-month period. And you as a criminal defense practitioner, I know many of us can attest to this, you don't necessarily have the time always to meet with us and come and testify very relevant testimony to what we're doing here, because criminal defense is unlike most other practices in law. Your boots on the ground every day. You're in the trench. You are getting after it every day, and so it's hard for us. So I want to thank you for taking that time to be here. I know you say a lot that comes through. I don't know if you share this same suspicion. I have found myself, if I'm in a face-to-face in an attorney booth, there's a little phone you can pick up. It's supposed to be a secured line. If I can talk loud enough and nobody hear the conversation and they can hear me through that little slit in the glass, I don't pick up the phone. Mm-hmm. I don't know if you share that same concern that I have, but I find myself, if the client can hear, I'm even suspect of the phone in the attorney booth, and even though, I'll probably always have some suspicion, even if this legislation were to pass, this puts it in the right direction.
Yeah, well, you'd have, and another thing is you have to talk pretty loud on those phones, I think, probably because it's the line is usually split for recordings. That's a fear, and then, maybe we're being a little paranoid. How do we know that there's not microphones placed in the face-to-face contact areas? Mm-hmm. But so far in my county and in my experience, I've never seen that. So.
And I can attest to, Bart, I've known you for a long time, and you're in and out of jail, not as a defendant, but as an attorney very often and in court. So I know you have a lot of experience with this. So thank you for being here. Chairman Crow.
Thank you. First, you made it sound like that it was terrible to drive down to Jackson, and that being in my district, I think it's a lovely place to live, and I try to get there as often as I can. In fact, I try to get out of Atlanta as much as I can and get home to Butts County. If you just make a trip to go across the bridge and go to Buckner's and eat lunch every time you have to go, it makes it well worth it. So, but y'all did bring up a point, though, that you'd mentioned earlier, Representative Panich mentioned that when you would call in and say this is being recorded, you would say, I'm the attorney's my bar number, stop recording. That made it sound like there's someone actively listening and doing. But when you say that, that doesn't do anything. Is that right? You're just saying it so that it's on the recording. You're putting them on notice. Correct. That this is a privileged conversation, right? And I'm not real familiar. Actually, that's a lie. I'm not at all familiar with the case that y'all are talking about, the Burns case. But it seems like that we're trying to, and again, my concern goes back to how are we going to implement this? And you mentioned some different alternatives that they could have, but it sounds like that none of those are really gonna help the most paranoid among us, who may be thinking that there's, and to that point, it seems like that if you could just have a code to put in, at some point, no matter what you do, if they're listening, they're listening. And so I don't know that going through requiring all the expense and the hassle of trying to put in a whole nother phone when you could just tell them not to use our recorded conversation. I don't know why that is insufficient. And if someone can educate me on that, Maisie Lynn maybe, or never mind, my non suspicious friend over here will do that. So.
I think Chairman Smith, you
Phone
help?
a suspicious friend. I just have that healthy Republican distrust of government. That's what it really comes down to. I would say this. I would agree with the gentleman that should, once we get out of here, take care of everything, just having that statement. What we are running the risk of here is jeopardizing confidential information conveyed by a client. For us to wait and a prosecutor look at what we passed, or if we do not pass this, we are setting up a scenario of where we have to test this. And we go to court. Well, it goes one way or the other. It gets appealed, and we come right back here again. And in the meantime, confidential conversations between attorneys and clients are put at risk to test that hypothesis. I know Judge Crowe would be admirable and noble and recognize and know that conversation is not coming in. But I don't know if Judge Smith would have that same opinion. And so this clarity, I think, is what we're trying to get to. I mean, I would be lying if I didn't share that when I saw this decision come out, I hit the roof. And thankfully my paralegal came in there and pulled me back down. But to me, it's a sacrosanct privilege between attorney and client. You know, there's a lot to that, and I think that although I would agree with the gentleman making that statement during the call or at the beginning of the call would be when you would make it, I don't think testing this and the risk it runs is something that we would like to do, and that's why the representative brought this legislation.
Chairman Leverett, or which one of you four is on that mic? Chairman Leverett.
It's me, Madam Chair Lady. I'm just curious, in your experience, do sheriffs or their staffs tend to be solicitous of your request for an ability to communicate in a confidential manner, or they act like, well, he's in my house right now, anything he says is my business?
They're very decent, and they're I've never had one be abusive on that. They so far respected my request for privacy.
And perhaps while they're neutral.
Well, you know, they have a system set up, but yeah, when I say privacy, sometimes you have to meet with your client in the back of the courtroom or in a holding area in the jury room, and the sheriff, they take it very seriously. They're like, even if they hear something, they know they can't tell anybody. I suppose if your client says, I'm going to kill so-and-so, the sheriff's going to say that's not privileged, but otherwise...
Well, that might not be privileged otherwise.
Yeah, it wouldn't be privileged. But the sheriffs, in my experience, are very careful to assist me in protecting our privacy.
Okay, thank you.
All right, thank you. We're going to move on. Thank you. Thanks, Mr. Cohen, for being here. That's all I see as far as who signed up for House Bill 460. I'll entertain any motions at this time. All right, we have a motion and a second. Any discussion? Chairman Leverett?
Yes, ma'am. Could I move to amend House Bill 460 in the following particulars?
Okay.
on line 17 by striking the words federal or at the end of that line. So the line would read, other proceeding in a state court. And then in line 22, delete the words United States and the comma following. And then on line 23, delete the Article A before the word state and the comma after state, I believe would be grammatically correct, Madam Chair Lady. So
I'm sorry, what was the last part?
So the last part was on line 21 at the end of the line to delete the word United States and the comma that follows it.
Right.
And then on the next line
23.
to delete the Article A at the beginning of line 23 and the comma after the word state also at the beginning of line 23. So that phrase starting about the middle of line 22 would read, or other authority of the state or a political subdivision thereof.
I see.
Okay.
All right.
Don't want to offend our friends in the federal system.
Got you.
I
All right,
think
did
they'd more
everybody,
ignore us than feel offended.
What's that?
I think they'd more ignore us than feel offended.
everyone on the committee understand Chairman Leverett's amendment? All right. Do we have a second?
Second.
All right. All those in favor of passing Chairman Leverett's amendment, say aye.
Aye.
Those opposed, same sign. All right, that passes. And we have a motion and a second, HB 460 with Chairman Leverett's amendment. All those in favor say aye.
Aye.
Those opposed, same sign. No. All right, ayes have it. So we'll go ahead and pass. Thank you.
Thank you.
Committee.
All right.
This room makes me
Thank
itch.
you so much for waiting.
Hey, so glad to be here.
Chairman Carpenter.
Such a pleasure.
It's
Such a
HB
pleasure.
237.
Yep, House Bill 237, LC 481428.
Okay.
Just real quick, I did learn a few things as I sat here. So I learned that it's important to have clarity, and it's important to have a test, and I think that's what this bill does. In 1843, Ralph Emerson said, "Never strike a king unless you're sure it will kill him." In 1969, Johnny Cash said, "I seem to fight my whole life through." In 1973, Bob Marley declared, "I shot the sheriff, but I did not shoot the deputy." In 1982, Bruce Springsteen said, "Me and her went for a ride and 10 innocent people died." And then one of my favorites in 1991, Cypress Hill saying, "If there's something you can't understand, how I could just kill a man." And so what this bill seeks to do is it seeks to provide artists and creatives an opportunity to express themselves without that expression being used against them in a court of law. I think it's important. We've seen issues around the state of Georgia, but also around the nation, as more and more people are producing music, other art forms, that their expression is being used against them. And so all this legislation seeks to do, it still allows it to be brought up in court as long as they meet the following four things. And sorry, I got a lot of paper here. So it's basically a four-prong approach. The first prong is literal or figurative. Is the content literal, or is it the artistic license? The second one is matching the allegation. Is there a fact pattern connecting the art to a specific allegation? So did the artist say, "I'm going to shoot Johnny," and then he shot Johnny? And number three, is the fact of it being disputed, or is it already stipulated by the defense? And number four, value is not provided by other evidence. So since this, the First Amendment is a gray area to begin with, is there a distinct, how do I say this word, probative value not provided by other admissible evidence? And so I think, as someone that's a big fan of the creative industry and the chairman of Creative Arts and Entertainment, this legislation is important to address, to provide courts, prosecutors, etc., with a test so that they're able to present the evidence if it's necessary. But it provides the guardrails necessary so that creatives are protected when they make the art that they make for money, and when they're able to express themselves. And I'll be glad to take any questions.
All right, any questions from the members? All right, and just to for the lawyers in the room.
Yeah, please.
It seems that we're basically saying that this evidence is inadmissible, and then in order to have it admissible, you have to prove by clear and convincing evidence the 4 prongs that you had outlined.
Yes, ma'am.
Is that correct?
That's
Okay.
correct.
All right. We have several people signed up for this to speak on this bill, so I'm going to go ahead and, if you want to sit there.
Slide to the left.
Okay.
Absolutely.
And I understand one of the witnesses has a flight to catch, so I'm going to kind of go out of order here. Phil Woloski with Free Our Art.
Actually, Eric has the flight to catch.
Oh, okay. Okay, Eric. Let's hear from Eric Nielsen. Right, it's a busy airport. We don't want you to
I appreciate it. Thank
miss your flight.
Well, there's a snowstorm coming to Richmond, and like Atlanta, snow will shut that city down. So.
Okay. All right. Thank you for being here. If you can state your name and who you're with. And
Sure. My name is Eric Nielsen, and I am a professor at the University of Richmond. And if I can I start?
Sure.
Okay. And I'm here to express my strong support for House Bill 237. If signed into law, this bill would provide long overdue protections for creative expression. I would like to thank the sponsors of this bill, particularly Representative Carpenter, for supporting this important legislation. And this reform is urgently needed. In courtrooms in Georgia and across the country, prosecutors are increasingly introducing creative expression as evidence in criminal proceedings. My own research in this space has focused on rap music, which is overwhelmingly the most common form of art presented as evidence in courts. It has been targeted and punished by the criminal justice system for decades, but it has reached an apex in recent years, and clearer guidelines are necessary to support innocent defendants, our already overburdened courts, and the taxpayers who finance our system of justice. In practice, rather than acknowledge rap music as a form of artistic expression, police and prosecutors argue that the lyrics should be interpreted literally, in the words of one prosecutor, as autobiographical journals, even though the genre is rooted in a long tradition of storytelling that privileges figurative language, is steeped in hyperbole, and employs all of the same poetic devices we find in more traditional works of poetry. My PhD is in English, and I'm both shocked and dismayed by the way distinctions between author and narrator are discarded, and the importance of artistic license is ignored. My master's degree actually focused on Shakespeare, who attracted his own share of controversy in his day. With all the violence in his play, imagine the field day prosecutors could have if today they simply cherry-picked the most violent verses and portrayed them as autobiography. Similarly, imagine the fate of actors in violent plays or films, or performers of other genres of music like country or punk, if their works were used in a similar way. In such a scenario, to draw on a commonly used example, Johnny Cash may very well have found himself charged with shooting a man in Reno just to watch him die. My point here is that this tactic effectively denies rap music the status of art, and without legislative remedy, it sets the stage for pushing further into other forms of art. By presenting creative expression as literal confession, prosecutors gain a dangerous advantage in the courtroom and sometimes obtain convictions even when other evidence may be lacking. Today, no other fictional form, musical or otherwise, is misused like rap in the courts. And in the absence of meaningful legislation like this bill that sets common sense boundaries and guidelines, there's no reason why more forms of art won't fall into prosecutorial crosshairs. In the case of rap music, which is, by the way, a major contributor to Georgia's $24 billion creative economy, the extent of its use as evidence is jaw-dropping. Our research has identified close to 700 cases where rap music has been used as evidence, but that number is primarily based on cases that actually went to trial. It doesn't include indictments, which are sealed, juvenile records, which are sealed, and most importantly, plea bargains, which is the typical outcome in these cases. Very few actually go to trial. If we had access to all those records, the numbers would undoubtedly be in the thousands, probably tens of thousands. Research and appellate court decisions are aligned that rap music has the potential to be highly prejudicial. In one study, for example, divided subjects into two groups and gave them identical lyrics, violent lyrics, just lyrics on a page with no indication about the genre or the artist. And they told one group these lyrics came from a rap song. They told the other group the exact same lyrics came from a country song, and they measured their responses. And what did they find? The group that believed they were rap music found them to be more threatening, in need of regulation, and more literal than the exact same lyrics that were characterized as country. In another study, one that focused on the impact of rap lyrics on potential jurors, the researcher found that the set of violent lyrics that he presented to some of the study participants exerted a, quote, significant prejudicial impact on his test subjects, to the point that participants who read the lyrics were significantly more likely to think the author of the lyrics was capable of committing murder than those who did not read the lyrics. This is not and should not be a partisan issue. Weaponizing any art form against its creators is an affront to the First Amendment protections that everyone in this country should be entitled to, and people across the political spectrum should be able to agree on this. And in fact, that's what we're seeing. Over the past decade, high courts in states such as Massachusetts and New Jersey have issued strong rulings condemning the prejudicial use of art as evidence, but in the last year or so, the strongest rulings have come from far more conservative courts. Georgia, Tennessee, and Texas, all of them reversing convictions based on the misuse of art as evidence. I promise I'm almost done. Although it may be the way it's supposed to work, the varying circumstances in each case means judicial precedent is not enough to stop a practice that has continued and grown over several decades. For that reason, I strongly urge you to pass this legislation and help ensure it becomes the law in Georgia. In doing so, you'll be making a strong statement about this state's commitment to artistic expression, the First Amendment, everyone's right to a fair trial, as well as Georgia's commitment to being a home for a robust, creative economy. Thank you, and I welcome any questions you might have.
Thank you. Any questions from members? I don't see any. Thank you so much. Hope
Thank
you catch
all.
your flight.
Okay. Thank you very much.
All right.
Donate the biscuit.
All right. Phil.
Yes.
Phil Wilotsky. And can you push?
How's everyone doing?
Can you put the mic closer to you just
Sure,
to
I
make
can.
sure?
Of course,
Okay.
yes. Is
Thank
that,
you.
is that better? Okay,
Yes.
great.
If you can state your name and
Get it in here. All right.
All
Thank
right.
you very much. Yeah. All right.
state your name and your organization.
Yes.
Thank you.
Good afternoon. So thank you, Chairwoman Hung and committee members. My name is Phil Wilotsky, and I'm the executive director of Free Our Art. It's an organization formally launching next month, dedicated to advancing creative freedom and First Amendment rights for artists, in part through supporting bipartisan legislation all across the United States, like House Bill 237. Our coalition not only includes music industry leaders like the Recording Academy, the Recording Industry Association of America, and Warner Music Group, but also organizations like PEN America, the leading advocacy group for authors and novelists. Informally, our efforts date back more than 2 years with an open letter in the Atlanta Journal-Constitution and New York Times, signed by every major music industry institution, as well as artists as diverse as Morgan Wallen, Coldplay, and John Legend. For projects we're working on to be announced later, we have partnerships with global superstars like Metallica and artists like Tom Waits. All of this is to say, there is consensus among artists that legislation like House Bill 237 is appropriate, overdue, and strikes a common sense balance between public safety and First Amendment freedoms. Now, having worked on this issue for a while, I've come to learn that lawmakers often evaluate legislation with their head, their hearts, and their guts. And I believe that there are some other witnesses here, Professor Nielsen among them, who can make compelling arguments to your case, why this makes sense. With my time, I wanted to speak to your heart and your gut. I think that conversation, especially with the heart, starts with a question that I found lies just below the surface for a lot who are skeptical of this bill. And it's, if someone's creating art, whether it's song or film or novels or paintings, and they tell stories about violence, criminal behavior, guns, drugs, revenge killings, is that something that we want to protect? And I would actually argue, yes, potentially objectionable creative expression is precisely what we need to protect. Freedom of unpopular thought and speech are quite literally our first freedoms as Americans. Once you start down the path of incremental exceptions, you open the door to an unfree society. And this is not some modern liberal idea cooked up in a faculty lounge. It was James Madison, author of the Bill of Rights, who wrote, "Our First Amendment freedoms give us the right to think what we like and say what we please. And if we, the people, are to govern ourselves, we must have these rights even if they are misused by a minority." Or in a more modern context, to quote Vice President J.D. Vance when he challenged our European allies at the Munich Security Conference last week, "Free speech is in retreat. Democracy rests on a sacred principle that the voice of the people matters. You either uphold that principle or you don't." And I hope in your heart you see that this bill speaks to the values at the very center of what it is to be an American. Still, I can also empathize with the hesitation you have in your gut. We have great respect and regard for the work of prosecutors and the critical role they play in keeping our communities safe. But in the same way that guidelines are in place for a small minority of legislators who might step across lines of ethics or decorum, common sense guidelines to limit improper use of First Amendment freedoms are overdue across the United States for the minority of prosecutors who cross that line. It's why this law has been thoughtfully crafted to allow admittance, again, this is not a ban, to allow admittance of creative expression in the extraordinary circumstances where someone actually does tell on themselves. This is not a ban. We want violent criminals off our streets too. Now, at the risk of getting too academic, to make this more grounded, I want to offer an example using a real artist and real lyrics. Instead of the Johnny Cash stuff or the Bob Marley stuff, right, that everyone knows, I wanted to try it with a song you're likely unfamiliar with, right? So there's an artist called The Boss, and in a song he rhymed, "With a sawed-off 410 on my lap, I killed everything in my path. I can't say I'm sorry for the things that we done. At least for a little while, me and her, we had us some fun." So, this artist is obviously talking about a murder spree in the first person and showing zero remorse. And I'd note in real life, this artist owns shotguns and pistols. There's no aha here that he has a spotless record. He's had tax evasion issues at the start of his career and a DUI arrest not too long ago. But to offer a hypothetical that explains how these cases play out. Let's say there's a shooting after one of this artist's shows, and the investigators zero in on him being responsible. At the heart of what we're discussing today is the question, is it fair game for prosecutors to try and use this creative work as evidence? And if you answer no, you should know that guardrails proposed in House Bill 237 would keep these lyrics out because there is not a factual nexus between the allegation of being involved in a shooting at a concert and the story of a murder spree. But let's say you answered yes or maybe for admitting this is a song. I'd ask if your mind changes when you learn that the boss's given name is Bruce Springsteen. Specific to music, I could have done this with countless of other acts. The Beatles, Taylor Swift, Rolling Stones, Grateful Dead, Cher, Miranda Lambert, Lyle Lovett, Maroon 5, Guns N' Roses. And beyond music, I could have done this with author like Stephen King, director like Martin Scorsese, operas like Don Giovanni and Tosca. Shakespeare's Romeo and Juliet is a romance set in the middle of a gang war. The last 3 of 10 iterations of the Fast and the Furious franchise were filmed right here in Georgia. They're films celebrating a gang of car thieves. Escapism, exaggeration, and fantasy are central aspects of contemporary popular art. And for those who think hip-hop is some unique category of violence and deserves special treatment, a 2019 University of Missouri study showed the frequency of reference to violence in hip-hop and popular music are identical. In closing, all art goes through an artistic lens. If you've got kids, you know that when you hand them crowns and a blank sheet of paper, they'll draw cats and dogs with unicorn horns. That's an artistic lens. In the most realistic paintings by masters, they use shadow and light to tell stories. That's an artistic lens. This lens is present in all forms of art, and it's why literal interpretation is so problematic and should be used so thoughtfully and so sparingly. That's the whole point of this bill. Creativity is not confession, and imaginations don't belong in an indictment. And yet we see growing encroachment. The artistic community is waving their arms and saying, everything covered by this law may not be your cup of tea, but we ask you to treat it with the same regard you treat the art that you love. Thank you for your time.
Thank you. And we have one question.
Yes, please.
Chairman Gunner.
Thank you. Are you an attorney?
No, sir, I'm not.
Okay. Well, I'm going to ask you a question.
Please, no, yeah. I'm very familiar with this law, so I can kind of at least... and then we also have another witness who is Georgia.
Would you agree with me that this would almost never this kind of evidence would almost never be introduced based on the standard of clear and convincing evidence?
So this issue was actually raised to us a little early as it relates to, well, first off, I wouldn't, because I think that if, you have a situation where someone actually does admit to a crime over a beat, right, or whatever have you, I think there is totally a path where if someone says, I killed John in front of his mama, and then he's accused of killing John in front of his mama, that's something where I can't see how that isn't admitted. Right? Just a situation involving that. On the other hand, too, if you have, I know in speaking to the Prosecuting Attorneys Council, they had flagged that, hey, in the state of Georgia, clear and convincing is a particularly unusual standard. I should note that across the United States, we're advocating for these bills. Clear and convincing applies in some other states like Maryland, for example. So if that's something we're in Georgia, there needs to be a tweak to adjust to Georgia law. Now, obviously, I would defer to the sponsor, but I think our coalition would be supportive of that. But if you're saying like clear and convincing is the hill you die, I mean, that's something I think that is a reasonable piece. That if it's a situation where you're talking about clear and convincing versus preponderance of evidence, okay, that's something at least our coalition could get behind.
So how many of these other states have a clear and convincing standard?
Well, presently, there are not any bills with this language in place in the United States. There are active bills in Missouri. That's a bipartisan bill both in the House and Senate. Maryland, that's led by a Republican sponsor in the Senate and then is bipartisan in the House. New York, and then, there's going to be a federal bill upcoming. But that's where we kind of are right now in terms of the roadmap. This bill with the language as is was introduced by the GOP Speaker of Louisiana 2 years ago, ended up getting watered down a little bit, but that's also just has things to do with the Napoleonic Code versus common law that they use. But yeah, that's where we are right now. And California has a law, but the People's Republic they're working on a different track and have some other different laws.
Thank you.
All right, any other questions from members? I don't see any. Thank you so much.
Thank you.
All right, let's have Attorney Shay Lawson.
Good afternoon.
If you can say your name and if you're with any organization or.
Okay. Good afternoon. I'm Attorney Shay M. Lawson. I'm an intellectual property and entertainment attorney based here in Atlanta, Georgia.
Okay, you can move forward.
As an intellectual property and entertainment attorney, I support creatives that span film, television, literary works, dance, and music. These clients that I've represented for the past 15 years not only bring their creative works to life, but they also employ hundreds of people in the state of Georgia. They employ single mothers. They employ hardworking dads. They employ individuals that are just looking for a way to make ends meet. As we all know, the entertainment economy in the state of Georgia brings in billions, and it needs our protection. And so we are asking that you support HB 237 to protect the right to creative expression here in the state of Georgia. I do want to reiterate that HB 237 is not a blank check. It is prudent legislation that properly protects the right to free speech via creative expression and also in part the right to a fair trial. It's been carefully crafted, as the chairman has brought out, to have very specific knowledge, and it respects the DA's role in society for public safety while preventing the use of purely imaginative creative works by imparting this four-part test. There's a demonstrated need to protect free speech by governing admissibility of creative expression. I know that there are concerns about whether this is the correct standard or whether this is something that the state should take up. In the same way that Georgia Rules of Evidence 406 govern habits of routine and practice, or 407 governs admissibility of subsequent remedial measures, the nuances of art and poetry and books have to have the same level of particularity and nuance in regards to interpretation that will require similar guardrails that rise above the relevancy rules of 401 to prevent a free-form attack on creative individuals in the creative industry that brings billions in economic impact to the state of Georgia. On the federal level, a judge has even pointed out that there's a lack of judicial guidance and burden shifting to the jury to ask 12 people with less context to understand and decipher what is literal versus figurative, and that is fundamentally and deeply problematic. The Supreme Court of Georgia in March of 2024 also said in Baker v. State this exact same outline, that other states are moving on with similar legislation. As Phil just recently brought out, Missouri with bipartisan support in Maryland. The legislation successfully passed in California and in Republican. We here as Georgia, we often follow the federal rules of evidence. We know at the federal level a mirror legislation has been introduced, and we have an opportunity here in Georgia to continue to take the lead. We have a problem that has moved from its infancy to a fully mature issue, and we can get ahead of it here in the state of Georgia by passing HB 237. We're not saying that judges are always wrong, or that prosecutors are wrong, or that there should be a blank check to say or do whatever. But we are saying that there is a need to set standard rules for the courts to give the best chance at getting it right as opposed to conjecture. The right to fair trial impacts Georgians in urban areas, in rural areas, families on both sides of the political aisle, and support of HB 237 sends a clear message to Georgians that they can trust our judicial system to be one that's focused on solving crimes with integrity and efficiency and fairness to Georgians, and that our legislature treasures the jobs and economic support that the creative industry brings to Georgia. Thank you so much for your time.
Thank you. Any questions from members? I don't see any questions. Thank you.
Thank you.
Ryan Pelfrey? Ryan Pelfrey? Oh, okay. I'm gonna see right outside. Oh. Well, that's Sam Owens.
That's not Ryan Pelfrey.
Yeah.
If I can get Sam up there to speak with me, this is a miracle
Are
right
you
here,
Ryan?
folks.
Ryan Pelfrey?
Yeah, that's correct.
Yeah, for 242.
Oh, okay. I apologize. Okay. You're right. That's too soon, Sam. You can sit down. All right. Okay. You can go back outside.
Go back on the smoke break.
Christopher Bruce.
I hope y'all don't treat me like that. Something else. Madam Chair, members of the committee, it's good to see all of you. Happy Tuesday.
Oh, I'm going to, okay.
There we go. My name is Christopher Bruce. I am the Policy and Advocacy Director of the ACLU of Georgia. I'm going to do something that I typically don't do. I see people saying they're in favor of this bill, so I'm going to keep my remarks very short, okay? Because we are in favor. See, there you go. We are in favor of this bill. I just want to make sure that we're going on the record of saying that we are in favor of this bill. As you know, ACLU is a nonpartisan organization that specifically champions First Amendment rights. We work with Democrats, Republicans, and the people to make this happen. So let me say this. Over the last several decades, prosecutors have increasingly treated rap lyrics as confessions to crimes, threats of violence, and evidence of gang affiliation. This issue coined as rap on trial. This has happened across the nation as well as in the state of Georgia. So again, as a steadfast champion for the First Amendment, we strongly disagree with Judge Glanville's ruling in the case that dealt with Young Thug's trial, allowing rap lyrics to be used as evidence to create a chilling effect, discouraging artists from expressing themselves freely. If artists fear their lyrics might be misconstrued and used against them in court, they might self-censor and undermine the core purpose of our free speech protections. We've already gone over the fictional use of dealing with exaggerated artistic lyrics, and we've already talked about what deals with novels, movies, and other genres that deal with autobiographies and how those are not used in certain groups. So, country music. Now, previous person already talked about Johnny Cash. I'm going to go to Dolly Parton. Okay? Dolly Parton's Banks of the Ohio. You haven't heard this song? You should. which is about a jilted lover stabbing a victim in the heart. This is Dolly Parton. Nobody's going to arrest Dolly Parton, right? So singling out rap disproportionately infringes upon the free speech rights of Black and Latinx Georgians and puts them all at higher risk of criminal prosecution. In almost every case, use music lyrics as evidence. The defendant has been Black or Latinx. It also sets a dangerous precedent that could extend to other artistic genres. So considering the immense risks posed by usually allowing rap lyrics to be used as evidence in a criminal trial, we support HB 237, which would require strong and relevant connection between the lyrics and the crime of lyrics to be used. Rap is an art, not evidence. For this reason, we urge you to vote yes on this bill, and I yield for any questions.
All right, thank you. And I do not see any questions. Thank you.
I'm going to go take my smoke break with Sam.
All right, Maisie Lynn.
This time I'm joined by we have 2 lawyers of the week this week. I feel flush with expertise. This is Haley Hudler. Quickly, we're coming from a slightly different angle than the people you've heard from so far. From the criminal defense bar's point of view, HB 237 offers a reliable rubric for not only better ensuring the First Amendment rights you guys have heard about and their protection, but also to help ensure that juries are provided reliable evidence when a crime is being prosecuted. The search for reliable evidence is foundational to a criminal prosecution and can be seen in how evidence that could arguably be considered probative or helpful in determining what occurred can be kept out of trial in certain circumstances to avoid undue prejudice. We are familiar with this in the evidentiary context under Federal Rules 403 and 404B, which we have here in Georgia as well, which involves a balancing test to consider the probative nature versus the prejudicial nature of the evidence. We also have a test of the reliability of hearsay evidence. So considering particular types of evidence, and in this bill, we would say this bill is illustrating how speech is special. There are other special types of evidence that we do consider under a different rubric all its own, and we believe here this is a very reliable one. Did you have some to add about this, about how it plays out for you in practice?
Yeah. I mean, I think that, as Maisie Lynn mentioned, without...
Can you get closer to the mic? I'm sorry.
My pleasure.
Thank you.
So as Maisie Lynn mentioned, without a special test for artistic expression, as this bill is suggesting that we adopt, we'd be relying on the evidentiary rules regarding relevance and character evidence under Rules 403 and 404B. And it's hard, the relevance standard is hard to apply in a uniform way. The standard is whether the probative value of the evidence substantially outweighs undue prejudice. And a lot of people forget the word substantially when they're talking about 403 and just say, oh, okay, well, does the probative value outweigh the undue risk of prejudice? When we want to try to give special importance to a particular type of evidence, then we should have a standard that allows for more uniformity from judge to judge and jurisdiction to jurisdiction. And something like this would certainly help with that. I think that in Fulton County, where rap music is really prevalent, for example, using a relevance standard there, you would have a very different outcome as to whether this kind of evidence would be admissible in trial than you would in a much more rural county like Tift County, where rap music isn't as prevalent. Essentially, it's not going to exclude this evidence from coming in when it really does, the probative value really does substantially outweigh the risk of undue prejudice. It's just an acknowledgement that artistic expression deserves a special treatment under evidentiary rules.
And the other part that we appreciate about this bill is just the procedural realities in it, that the pretrial nature of the hearing that would be held to determine the admissibility of this evidence allows and forces really consideration of the real issue. It allows time for thoughtful research that can have the advantage of not catching a lawyer who's inexperienced with this particular subject matter off guard, potentially burdening the case with another, you heard earlier about ineffective assistance. That could happen here too. And when an ineffective assistance claim is made, assuming a post-conviction, it's protracted litigation that's expensive. So being able to have this kind of determination as the bill lays out pre-trial would be protective of that as well. And to the point that was mentioned earlier about the standard, I think having the judicial pretrial determination doesn't give me as much pause about the higher standard. I think a judge is well suited to making a clear and convincing determination where it might be a little more fuzzy for the general public to determine what's the difference between preponderance and clear and convincing. But like the folks who testified before us, GACTL isn't married to the standard as it's presented in the bill, but just to let you know, it seems like a very accessible decision for a judge to be making. I mean, they make it in other determinations, like for instance, parental right terminations or things involving wills. It's a common standard for a judge to have considered. And then I just wanted to just kind of narrow in on what Ms. Hudler was saying about the judges and the equity across the state, and just to remind you that we have over 700 judges in the classes of courts that we understand that Title 24 would be used by. And so bringing a standard rubric to that body of jurists to allow them something to rely on in making these determinations is a benefit to, I would like to think that Judge Gunter might agree, but can't quite tell from his face. No, he does not agree.
I can answer that question for you, and that's the first time I've ever heard rubric.
Well, nonetheless, we believe it would be helpful for the other 699 seats represented to have some continuity in the way that these kind of decisions are being made about this important evidence.
Thank you. Any questions? All right, I don't see, I do.
Judge Gunter.
Judge Gunter. Chairman Gunter.
Okay, I would agree with you if it was a preponderance of the evidence, but the clear and convincing standard is the highest standard like in a civil case.
Right.
Okay.
Mm-hmm.
So, in my mind, clear and convincing would hardly let any of this evidence in, especially if the artist changes the facts just a little bit in the song or whatever it is that they're putting out there, or they tweak it just a little bit. It would make it such that it wouldn't come into evidence. And so I think this really, for prosecutors, makes the effort useless. So
I see your point. Don't agree with it either, but I just
I'm
see
sure
your
I don't agree with yours either.
I know. We often dance this way. We often dance this way.
What I'm hearing is there's a chance that me and you can meet in the middle. That's what I heard there.
The conditions that you have on there, I don't have a problem with. But the standard, I do. But everything else, I'm okay with.
Okay. Any other questions? I don't see any. Thank you. And lastly on this bill is Randy McGinley and Herb Cranford. Good afternoon.
Good afternoon. Thank you guys for hearing from us. My name is Randy McGinley. I'm the DA in the Alcovy Judicial Circuit, which is Newton and Walton County. I'm also the president of the DA's Association. If you want to go and introduce yourself, I guess.
Yeah, hey, Herb Cranford, Coweta Circuit DA.
A couple of things I want to speak on. One is when this bill was brought to our attention, as president of the DA Association, sent out something just to all the DAs, trying to get feedback on this because I think that's an important subject matter. I've not had a single DA respond saying that they support this bill. That's a bipartisan group of DAs who all responded they oppose this bill. And some of those concerns, I mean, everybody up here has talked about music lyrics and song lyrics, but the bill itself, as written, says, covers visual art or other such activities or media. And the unintended consequences of this bill, I think, is a big concern for the DAs. This is something that, and obviously the bill now says, or I say now, but shall not include tattoos. I believe there's been previous versions, maybe here or other states, where that was not included because people started objecting to that being an issue. And the reason I say that is there's things such as people throwing up gang signs, things like that. Is that art? Some people would argue it is. That there's a number of other things, that videos on social media, things like that, that will fall into this and have to argue this over and over and over again. But the reality is, I guess, from across the board, DAs from small jurisdictions, medium jurisdictions, large jurisdictions, all just believe this is unnecessary. The current evidence laws cover this. 401, which no one's talked about, evidence has to be relevant first. And then there's the 403 balancing test. All this has to be relevant in these sort of hyperbole songs that are brought up where there's no evidence someone actually committed those crimes. Of course the state is not using that. Prosecutors aren't out there looking for evidence. Often this is sort of stuff that's thrown in our face by the defendant themselves. I don't know what district attorneys that, when it's said that they are just viewing lyrics not as artistic things, of course we view it that way. We believe in the First Amendment. Prosecutors believe in upholding the law. But this is something that is not necessary. The current evidence laws cover this. There's been a couple of examples that have been brought up. But I will say those examples include people who have raised their hand and under oath pled guilty to offenses involving gang crimes. It's just the reality of that case. There's other case that out of Houston County, I'm not sure if anybody brought that up, but that was overturned on appeal, which is just another sign that the current rules work. One other concern I think needs to be brought to the court's attention is this is something that I think under the current limited right the state has to appeal pretrial rulings, this falls into a very small subsection. I think we'd have to file an appeal within 2 days of the ruling, and it has to be with, the ruling has to be made at least 30 days before trial, or a motion that was filed at least 30 days before trial. So there's going to be some concern about the state having to appeal this, because this would be a big change in the current evidence standard and the way that courts view this, and it's something that would likely have to be hashed out with the appellate courts. And I also strongly agree with Judge Gunter that the clear and convincing evidence standard is just entirely too high when it comes to evidence. The idea of jury trials is to put it's a search of the truth is what trials are, right? Put that evidence in front of a jury and allow them to determine things. What are the facts, and apply that to the law that's given to them. To a certain extent, we're sort of not trusting juries with this law. Jurors are smart. It's a group of 12 people that can figure out if something is garbage or not. And the idea of evidence going before a jury is, with almost every piece of evidence, there's at least two views of what that evidence shows, right? I mean, the prosecutor's arguing something, the defense is arguing something else. Just because there's disagreement doesn't mean that evidence shouldn't come in. And so a clear and convincing evidence standard is entirely too high, but the bill itself, I just strongly believe is not necessary. I think the current evidence rules completely cover this. This is not something that's been done anywhere else. I know it's been proposed, but being proposed somewhere else doesn't really mean a whole lot. And so, as I say, just personally, and also as the president of the DA Association, the DAs are against this bill for the reasons I've stated. And I don't know if you want to ask questions now or let DA Cranford go ahead and then ask questions after that.
You can move forward. I don't see any questions right now.
All right. Thank you, Madam Chairwoman. I agree with what DA McGinley said. I think our rules already cover this. Thinking back to when we passed our current evidence code, as I understand it, a whole lot of work was put into that, modeling it on the federal rules of evidence. When the time comes, if Congress amends the federal rules to address this kind of thing, then we're in a different situation, and we can come back and consider it. But I think there's a reason that hasn't happened yet. The state of Georgia put a lot of work into modeling its rules of evidence off the federal rules. I agree with what Mr. McGinley said, that this is already contemplated in the rules of evidence. And the one case I'm aware of in the state of Georgia where this was, a problem on appeal, the case got reversed. So I think the current rules of evidence are working. I will say the state of Georgia's rules of evidence, in the code it says they're rules of inclusion, right? And so this statute, I think, inverts that. for this specific thing, it's not going to be a rule of inclusion. The state has to meet some higher burden to admit this evidence. I don't view this as, art versus evidence. I mean, speech is protected by the First Amendment, but if your speech is relevant to the commission of a crime, then it's appropriate to use that against you. And as Mr. McGinley pointed out, it is appropriate for a jury to consider something that has a tendency to show what either side is alleging it shows. So a defense attorney could file a motion to exclude this evidence. If a judge lets it in, the defense attorney can get up and cross-examine whoever's admitting it. And in closing argument, they can argue, this was just a song. This had no meaning. This was not related to the crime. All that can still happen in front of a jury under the current evidence code. And, there's been talk about rap lyrics and focus on that, but my office has sent a couple neo-Nazis to prison under the Gang Act. And, if some of those groups are engaged in like kind of heavy metal thrash music or something, and if we had a neo-Nazi that shot at an African American or a Jewish person, and we found one of their songs talking about, if I see a black person or a Jewish person, I'm going to shoot at them. Yeah, like I would want to admit that to show they intended to shoot at that black person or Jewish person, to help me prove the crime itself, but also that they did it for a specific, gang-related or hate reason. So I just, I'm sympathetic to artists and their desire for their speech not to be chilled, but and with respect to the sponsor, I think this is a solution that's looking for a problem that isn't a big problem, as I see it, and so I would just caution the committee. I know Chairman Gunter raised clear and convincing evidence. Looking at the language of the bill, although I'm opposed to it as a kind of matter of principle or philosophy, but element one is the defendant intended to adopt the literal meaning of the work as the defendant's own thought or statement. How does one prove that they intended to adopt it as a literal meaning? Two is there's a strong factual nexus. I don't know if Judge Gunner's ever seen in the law anywhere the definition. What is a strong factual nexus? I've never seen that. I don't know what that means. There exists relevance to an issue of fact that is disputed. Well, that's redundant of the current code. And then four, there is distinct probative value provided by other admissible evidence. I'm not sure what that means in the context of the statute, frankly. Like, we have to show there is distinct probative value provided by other admissible evidence. So there has to be other evidence that shows the same thing the lyric shows. Is that what that's saying? I'm not clear on that. And so if, again, like if a neo-Nazi shoots at, a person of color on the street and he didn't say why he did it, but I have, a song he wrote saying that he's going to shoot at any person of color he sees on the street, that might be the only evidence I have to show what his intention may have been. And the defense attorney can argue, no, that's just a song. It has no relation to this. So I think the current evidence code covers it. Happy to take any questions. And I guess I'll end by saying, if Dolly Parton came down to my circuit and committed a crime and wrote a song about it, I would prosecute her for it.
Easy, man.
And I like. I may not like Dolly as much as Representative Smith, but I like Dolly a lot. Like,
not surprised.
All right, thank you. Any questions? I do not. Well, I do. Okay. Representative Roberts.
So it is my understanding that Louisiana has recently passed a similar bill to this, so we would not be the first, and California was the first to do it, so there are two so far. I guess my question is, the case that was over, how often have you utilized art where it hasn't been overturned? And then how expensive was that case for the state to have it overturned when we could have done this analysis on the front end is, I guess, what I'm...
Personally, I've not had any case out of my jurisdiction that's been overturned for something like this. I think everyone kind of focuses on it being used at trial. There's times when it's also been used as such things as revoking someone's bond. They have bond conditions that have no direct or indirect contact or not intimidate witnesses. And then there's, social media videos and things that shows them, to me, is intimidating those witnesses, putting that out there and doing it in some sort of song form, if they want to call it that. But so it's not just used for trial, it's used for other purposes as well. And those aren't things that are necessarily going to get appealed. And I guess the cost question, that's a hard thing for us to answer. We don't break that down ever. And I mean, the cost of something that's a violent crime, to me, doesn't really matter.
As I understand it, the issue in that case, and I'm happy to be corrected, is, one, I don't think there was gang charges in the case, and I think a rap song was introduced to show some kind of association between people. So, like, there was no relevance of the content of the lyrics or the music. And so I think that prosecutor and that trial judge made a mistake to allow that to be admitted, for the for the content of that stuff to be admitted. And that's why it got reversed. And I think we've had a gang case where somebody wrote some kind of lyrics that seemed to be oddly relatable to the thing that had occurred, and that was for the jury to assess, whether were they really talking about what they had done or not, but this would establish, a really, really high bar to Representative Gunner's point, and for one case to be overturned in the midst of all of these so many songs out there. I just, my view is, the current evidence code is handling this appropriately, and except for one instance that I'm aware of, prosecutors and particularly trial judges, who are the gatekeepers, are doing their job in making sure, people's rights aren't being violated.
I know, but somebody like me singing Earl's Gotta Die is going to be a lot less likely to have it used against them than someone else, so it just feels prejudicial to me.
I understand. I Google searched a moment ago, it may be that rap seems to be targeted because there's a lot of rappers involved in shootings and being murdered. Like, if you look at, Google any other kind of artist in terms of being shot or murdered. I mean, there's unfortunately examples of that recently and in Georgia. So I would like to protect the victims of those shootings, and if I got to use somebody's statements made in lyric form, I think that's appropriate.
All right, Representative Penish.
Does anybody have the case site or can tell us what happened in the case that was reversed? I don't know what the...
Baker v. Georgia,
wait,
yeah.
it's in the binder. Hold on. Sorry. Thank you. I didn't know.
All right. We're going to, Chairman Smith.
So, just wanted to ask this question for clarification. If 420 would exclude it under this current iteration, let's say it passed as is, are you saying that 403 would not still allow an avenue for that evidence to be admitted?
I think 403 applies regardless, but
so they could still get it in under 403, notwithstanding 420 being passed.
I think we'd have to get through 420 first.
Okay.
Right.
Yeah. So I think 420 would stop us before we even got to 403.
Okay. Thank you.
All right, any other questions? I don't see any questions. Thank you.
Thank you.
Right,
That
thank y'all.
ends all the testimony. Chairman Carpenter, I'll have you do a closing for us.
Well, I mean, it's been a long day, guys. I don't have much for closing. I will say that I think Dolly Parton covered that song. It was a Bill Monroe song on the banks of the Ohio. and I did find a little humor in the fact that the code section would be 420. But other than that, I would love to hear the committee questions or thoughts or as we go through the process.
Okay. Any questions from the members? All right. Chairman Gunner.
Would you be opposed to an amendment?
I mean, this is y'all's committee. I'm just here to watch the fireworks, so that's up to the parties that be in the committee.
All right, thank you.
I'm just a pawn of y'all's game of chess now, sir.
All right. Thank you. Any other questions? Chairman Crow.
Not really a question, just if Chairman Gunner intends to offer an amendment. The first leg, I guess, or hurdle in this 4-part test, I have some confusion and concern about that as well. That's the part I'd marked a long time ago, not knowing how that would ever be overcome.
Combine that with clear and convincing evidence standard. Those two right there, nothing would ever come through.
Was that a question? All right, Chairman Smith.
Has anything ever come in under a clear and convincing evidence standard?
I can't think of anything. It's a pretty high standard.
All right, Representative Robert Prenich.
Clear and convincing in a criminal sense, my only, and I'm not even sure I'm right, is for affirmative defenses. Are there any other uses of clear and convincing in the criminal code?
I'm not aware of it. I mean, can you guys think of anything? Yeah, I can't think of it.
We found one in Title 17 related to competency and civil commitment.
Right, which is really more civil than it is criminal.
That's
I think
civil.
it's an affirmative.
But it's the competency and the Yes, agreed, it's civil.
Clearing affirmative defenses is any evidence.
Okay.
Yeah, and then we have to disprove based on a reasonable.
Got it.
Okay.
This is Frank.
Clear convincing is like taking away someone's job.
Right.
Mm-hmm.
It's very rare.
All right, the consensus is that it's very rare. Is that right? And or haven't seen it. Okay. Any other questions? All right, I'll entertain any motions. All right, we have a motion to pass. Any second?
Any second?
Second.
Hey, wake up, folks.
All right,
Come on
we've
now.
got a second.
Stay alive here. ACLU just came up McGreevy for the first time ever. Let's stay awake over there. Come on, people. Never seen that happen.
All right. Chairman Smith, do you have an amendment?
Yes.
Okay.
I would like to propose an amendment starting at line 15. I believe that's a period, notwithstanding my blue ink all over it. The period where you see it coming after tattoos in line 15, strike the period, insert a comma or gang signs. If I need to be more eloquent than that, PAC, speak now or forever hold your peace.
There is a statutory definition of criminal gang activity that covers a variety of things. I have to pull up the statute, but there may be something to reference.
Well, how about this? We'll do or gang signs, and when we get to full with it, we'll go back and include that if that would make things better. And then put a period after signs. And then in line 23, strike clear and convincing and insert by, I think there's a preponderance, or by preponderance of, by the preponderance of the evidence.
All right. Is that it?
That's it.
Okay. So we've got Chairman Smith's amendment. Any questions on his? Okay. Do you have a question or, okay, Representative Pennish?
Just like clear and convincing isn't really in the criminal code, it's preponderance in the criminal code. It's in the civil code. That's the burden. Is that a yes?
I didn't hear that.
Okay.
Okay. All right. So, any questions on, and/or actually, do we have a second on Chairman Smith's amendment?
Second.
All right. Do we have any questions on Chairman Smith's amendment? All right. I don't. Do you have a question, Chairman Gunner, or do you have an amendment?
Well, I'm looking at striking lines 24 and 25.
So, are you offering an amendment?
Yeah.
Okay. Can you say that your amendment again?
Striking lines 24 and 25.
Oh, I apologize. Chairman Gunner. We're going to hold on your amendment. We're going to consider Chairman Smith's amendment first.
Okay.
All right. So everybody heard Chairman Smith's amendment, and we have a second. All those in favor of Chairman Smith's amendment, say aye. Those opposed, same sign. All right. So we have Chairman Smith's amendment passed, and then Chairman Gunner will go to you for your amendment.
Okay. My amendment is to strike lines 24 and 25. And change the numbering that follows.
Okay. Is that it?
That's it.
All right. Do we have a second on Chairman Gunner's amendment? Second. Okay. Any questions? All right. All those in favor of Chairman Gunner's amendment, say aye. We're going to do a hand count on this. So those in favor, raise your right hand. Okay, we've got 4. All right, 4. All right. Those opposed, raise your right hand. That's 4, 2, 3.
Does Brian get to vote? I'm just kidding.
You don't want that. I'm about that.
What happens with the tie? Okay. I'm actually going to oppose that. So that becomes 4. All right, Chairman Gunner. So Chairman Gunner's that amendment fails.
Okay. Well, then this one probably will too, but lines 26 and 27.
All right, so we've got another amendment. So your amendment, this amendment, you're just striking 26 and 27. Is that correct?
Yes.
Okay. All right, do we have a second on Chairman Gunner's? All right, those in favor of Chairman Gunner's second amendment, raise your right hand. Okay. And those who object, raise your right hand. 1, 2, 3. And I'm going to object as well.
That's Leverett's fault. He shouldn't have left.
Yeah, I know.
He's in trouble.
I like the strategy.
All right. Any other amendments? Okay, I don't see any. So we'll go ahead and vote on the motion to pass House Bill 237 with Chairman Smith's amendments. Those in favor, raise your right hand.
1, 2, 3.
Okay. Those opposed, raise your right hand.
2, 3, 4.
Okay. Huh? All right, so that's 3 to 4.
It has been a pleasure.
Thank you.
Appreciate you.
Thank you, Chairman.
Absolutely.
We're going to take a 5-minute break, I think. It's been a minute. Yeah, let's take a 5-minute break. Thank you. All right, we're going to go ahead and start again. We have one more bill. It's House Bill 242, Chairman Silcox. Sure.
Thank you, Madam Chair. I bring to y'all House Bill 242. This is a really simple bill to be the last, but the best. All right? And it's unfortunate to this day and time that we even have to put this in writing, in my opinion, but unfortunately we have had one group in particularly that is consistently bothering or aggravating people while they're trying to worship. The best example I can give you was up in Cobb County at East Cobb Synagogue, that they were intentionally disrupting a religious service. And this is the same group that distributed the leaflets on people's driveways about a year and a half ago, Esther? Yeah. And so so this bill seeks to protect any religious service. This protects all religions from to engage intentionally to impede, disrupt, disturb, or interfere with the conduct of any religious service or a funeral. And that's the gist of the bill.
All right, thank you. Any questions? All right, I don't see any questions, and we do have one person signed up to speak, and Ryan Pelfrey. Thank you. The right bill this time. Thank you.
Make sure I'm sitting up here. Good afternoon. My name is Ryan Pelfrey. I'm the Senior Associate Regional Director for the Anti-Defamation League Southeast region based here in Atlanta. I'm going to be very brief. I just come here today to express our strong support for this legislation and then to express my thanks to you all and also Representative Silcox for all of your work on this. It's a really important bill to us, but also to other faith communities and institutions throughout the state. As Representative Silcox mentioned, this is not just to protect synagogues, it is for all faith groups and their institutions, and that is where I'll leave it.
Okay, thank you. Any questions? Representative Byrd.
Yes, thank you. Indeed, we do need to take care of everyone of all faiths. So my question is, does this limit the First Amendment at all by putting this out here? Please.
No, it does not, because it has to be intentional. You have to prove intent.
Okay, any other questions? All right, I don't see any. Thank you so much. All right, I will, Chairwoman Silcox, do you have anything else to say? Okay, I'll entertain any motions at this time. All right, we have a
Second.
Okay, and for what purpose? Chairman Smith, you have an amendment? Okay.
I do. Was talking about this with my pastor here a while back. Seems like sometimes we have a TED talk instead of what's actual service. And so this is where this amendment comes from. And so I would suggest by adding, well, now it's escaped me, but I would like to make an exception of where this does not include a guest speaker.
How about after observance?
I think that would be fair.
Yeah.
Okay, so it'd be at line 11 after observance. And line 19 as well.
And what's the exact language that you're amending, you're proposing?
Comma.
So just a comma after observance on line 11 and line 19.
Yes, it would be but does not include a guest speaker.
Does not, shall not.
Shall not.
But shall not include a guest speaker,
Mm-hmm.
comma.
But I want to make sure that would make sense as far as from a statutory construction part.
That goes
It-
after the comma?
Yes. From
All right, Robert Smith, if you want
maybe
to
there
come
needs
up
to be an
here and
exception at the end
Thank you.
clarifying.
Right, Mr. Chair, what I'm looking at
Yeah.
right now, what you just said is religious worship observance or funeral or memorial service or with the normal activities and functions carried on in the facilities and buildings. That's when you talk about guest speakers, that would be a normal activity and function. So you're going, if you want to carve that out, which, you know, that's, once again, this is your policy and your decision. If you want to carve that out, I would suggest, and I don't see Lake Council here to guide you either, that's where you need to put it at that point, because otherwise, you know, putting something in here about observance about or a guest speaker, you still have this back part talking about normal activities and functions. So you're going to need to account for what is it, because I don't, you know, that's my problem. That's what I was going to say, is that some faiths do recognize a guest speaker as being something, I'm
celebrity or somebody that would bring more people.
somebody, another pastor coming in. I mean, I'm trying not to get too biblical, but there, when Jesus wandered into the temples, he was a guest speaker.
Jesus shows up, we have a bigger problem.
I'm speaking to him in his language, but but just that's kind of the example I'd use, is that we have to be very careful when we start talking about guest speakers and carving it out.
All right.
To help us.
You withdraw.
I think that's your, they have to have that intent going in. And then, yeah, see what I'm saying?
I'll withdraw my amendment.
All right, Chairman Smith withdraws his amendment. All right, any
We still need the comma, I think.
any amendments?
After observance, twice.
All right, Chairman Smith.
I'll move to put a comma after the word observance in line 11 and on line 19.
All right, do we have a second on Chairman Smith's amendment?
Second.
Okay, all those in favor of Chairman Smith's amendment say aye. Those opposed, same sign. All right, that passes. Any other amendments? Okay, I don't see anyone. All right, on House Bill 242 LC 1427 with Chairman Smith's amendment, those in favor say aye. Those opposed, same sign. All right, it passes. Thank you, Chairwoman Silcox. And we are adjourned. Thank you so much.
Thank you, Rob.